We're live. Good morning, this is Senate Judiciary, Wednesday, April 17th, 2024. And we're taking up a little committee discussion about Proposition 4 and whether or not we should try to amend it before we get a floor vote this morning or this afternoon. So with that, the word respect has come up. Several people have asked what that means in the bill, and I'll let Eric explain. Eric Fitzpatrick from Legislative Council is here joining us, and I believe that it was in the 2019 and other versions of the Equal Rights Amendment, and we just kind of cut and pasted it, and now a few people have been asking how does that affect the constitutional amendment. So,
yes,
the word respect.
Yes, that's exactly right, Senator Sears. Eric Fitzpatrick with the Office of Legislative Counsel, and that's I think you've described exactly how the language was in there in the first place. It was in the 2019 amendment and in the other proposals. I think the committee was rightly focused on the different protected classes that are included in the language and the concept of how the Equal Protection Clause would work, and did not really focus on those two words at the time. And by those two words, I mean the way the language reads now. It states that the state shall not deny equal treatment and respect under the law on account of a person's race, ethnicity, et cetera, it goes on to the other protected classes. So yes, I've received several questions from people about the meaning of those two words. What does it mean to deny equal respect to somebody based on one of the classifications? And that sort of refocused my attention on the words, and recollected that it wasn't something that the committee had discussed in great detail or had really focused on. So I looked into it and was able to discover that the other states that have equal protection type provisions in their constitution do not have respect language. So this appears to be unique. Didn't find it anywhere else. And raised the question of, well, what does it really mean? How would it be interpreted? Because at least arguably, you're creating an ability for somebody to bring a legal claim against the state. That's the idea, the way the Equal Protection Clauses work federally and in other states, that a person can bring a lawsuit and claim that they were denied, for example, equal treatment based on their membership in one of those protected categories. Might that language then be able to say that, well, someone could bring a lawsuit just on the basis of feeling that they were treated disrespectfully based on one of those categories? The answer is possibly yes, and that might sweep more broadly than the committee had intended. And at the very least, whether you intended or not, you should at least be aware that that's a difficult term to interpret, and that would potentially create more liability than the committee had been discussing, I think, previously. I ran that by Professor Teachout as well, and he agreed with my read on that it's first of all, that the words aren't in any other state constitutional equal protection provision that he was aware of, and that it's unclear what it would mean, but could create the ability for someone to bring a lawsuit on that basis.
Because it's a constitutional amendment, if we chose to strike the word respect, we would offer an amendment on, we can do it on the floor, but there has to be another day's notice in order to do it. So it has to go on. Our amendment has to be on the notice calendar. It can't just be offered. So it would hold that things up for an extra day, which is not momentous. That's Senator Sheen.
Yeah, thank you. Thank you for bringing this up. It was something I had also noticed over the weekend when I was prepping, and I could not find just throughout the history of case law the word respect under the law compared to equal treatment under the law. And so there is a concern when there's no historical precedent or context or definition of what that means. I mean, everything else here has been at some point defined or listed in common law, but respect under the law has not, as far as I found, and apparently Professor Teach out and you as well. So yeah, that's so. I mean, I'd be open to amending the words and respect, just to make sure that we're. Yeah, I'd be open to amending that if the rest of the committee is.
Okay, and was that a motion?
I got one quick question.
Sure.
That's the trouble opening these things back up again. Senator Sheen came into a meeting yesterday that we had, and there was some concern over gender expression and the definition of this. Correct me if I'm wrong. There was some concern as to what does that mean? Does it mean? And the example that was given, I believe, was the storytellers were what was the cross dressers that were drag queens that come in, and if parents were opposed to this and this passed, would they be in violation of the Constitution for not allowing? So the gender expression is the one issue that came up, and you can. The questions were directed toward you on.
Yeah. So gender expression and identity are defined as being connected to sex as it relates to the 1964 Civil Rights Act. This is laid out in Bostock versus Clayton, which is a 2020 case. And then there's also this case that Eric provided, which is the American College of Pediatricians versus Becerra, which, at least on the federal level, also provides a definition of both gender identity and gender expression and transgender. And so, basically, the way, from what I saw in the Bostock case, considering that gender identity and gender expression are things related to sex, and if there's discrimination based on gender identity or gender expression, then it is potentially, depending on the facts, discrimination based on sex.
I'm just saying that's where the holdups are going to come. I'm just telling you right up front, that's where the holdups are going to come. So not the gender identity portion of it, the gender expression portion of it. And I don't know what this needs on the floor or whatever else, but I'm just letting you know what's going on. And Nader was there, so he knows what's going on. Was it in the 2019?
Yes. The only thing I would add is that, and I don't want to speak first.
Go ahead.
No, the thing I would add is that it doesn't, the fact that those categories are protected and listed in the language does not necessarily mean that a school or some other state actor can or can't make a decision based on whether it's a story hour, whether it's permitting people to use locker rooms, whether it's permitting people to participate in certain sports based on their gender expression. All this is doing is laying out the categories. Then the way constitutional interpretation works is that the courts are then going to have to decide based on what the state's rationale is for that. So the states, if someone brings a lawsuit and says, hey, you're, by having that story hour, is discriminating on the basis of gender expression, or by not permitting me to be on this particular sports team, that's a denial of equal treatment based on my gender expression, then that's going to go to the court. And the court's going to have to weigh, as it always does with equal protection claims, what's the state's rationale for this? What's their justification for making this distinction? And they may or may not say that the state action is okay. So my point is only that you're not going to be able to, at this point, say that this distinction is either going to be okay, or it's going to be required that we do this, or we can't do it. The court's going to have to analyze it the way they always analyze the Constitution, which is they'll balance the state's rationale for it, their proposed need for making this distinction, against the individual's right to be treated equally. And what they would answer in each case.
Geez, we never talked about our rationale on it. We never talked about our rationale on it.
Interestingly, I was just reading the Boston Globe. This week, the Fourth Circuit U.S. Court of Appeals ruled on West Virginia's law banning, former males from involved in sports, girls' sports. And the ruling was on a particular student who began identifying as female in the 3rd grade. And she was playing on a middle school, wanted to play on a middle school team in track and field and some other sport. And the court ruled 2-1 that in this particular case, she should be allowed. That doesn't affect the other rulings in 24 other states that ban trans students from playing high school sports.
But that's related to gender identity versus gender
Yeah, but
expression.
it's the same issue, right?
Well, interpretation.
It is the same issue. I mean,
I don't know why they have it in their choice if it's the same
I
issue.
remember watching Milton Berle dress up as a woman all the time. As a kid, you probably don't know who Milton Berle was, Bob.
Of course I do.
You're so young. A lot of his skits were dressed as women. Senator Husky.
So my understanding of the constitutional amendment is it's protecting against the state discriminating. So in an instance where a parent said, no, my kid's not going to that, this wouldn't come into play at all because the parent is not the state.
Right, it only applies to a state actor.
I just wanted to make sure that I was understanding.
Yeah.
So the issue for us is, should we offer an amendment that takes out the word respect?
And respect. I think you have to
And
take
what?
out you have to take 2 words out. And respect.
And, yes, right, well, it would be odd to leave the "and" there.
Right.
And the concern is that that's not well legally defined as to what that means.
On line 15 of page 2 of draft 3.1, it reads, the state shall not deny equal treatment and respect under the law on account of a person's race, ethnicity, sex, religion, disability, sexual orientation, gender identity, gender expression, or national origin. And this amendment would take out the 2 words "and respect."
And one other spot, just page 1, line 10.
Okay.
Same, it's just the same thing, and the same language is repeated in the purpose.
Good. So,
Take it out there too.
2 places. Thank you for catching that. I hadn't caught that it was in 2 places.
Yeah, sure.
So that would be the amendment. Shall we do it or not?
Yeah, I would support that.
I don't feel strongly one way or the other.
Senator,
I'm good with it. I don't feel strongly one way or the other on this. I'm good with it.
Senator Sheen has moved that we offer an amendment, a floor amendment, to take out the words "and respect" in 2 specific places. One in section 1 of the purpose on line 10, and in the actual article 2 on line 15. So the words "and respect" will be removed. Any further discussion?
Just a procedural thing, so this would be a floor amendment, and the floor amendment would be, so I wouldn't be doing the floor report tomorrow, or would I? And then doing the amendment on Friday?
It's an interesting question. I don't know, I could ask John Boomer that, whether that's permissible. I think it's probably up, I don't know.
I think you have to do the whole thing, and so you could do it next Tuesday because of other problems.
Right, because we can't really vote on the constitutional amendment if it hasn't yet been amended.
Right.
On the floor, you mean?
Right,
Right.
because there's only one vote
Uh,
on
Right.
constitutional amendments. There's no
you
second.
probably have to do the
reading.
amendment first.
Yeah.
In other words. Right.
Yeah, I think you'd have to, and you could hold off till Tuesday
I'm fine with that.
to make sure Eric's here.
I'm fine with that. Yeah.
Okay, so, is there any further discussion on the amendment to the constitutional amendment? Ben, well, I don't know, is there anyone who would not want their name on the amendment? I'm assuming that we can't do it on behalf of the Committee on Judiciary.
Correct. You have to do, I checked with him on this. It's gotta be individual
It would be
members.
the 4 of us, unless somebody wanted their name. So not hearing anyone, then just put it, write it as the 4 of us and check with Senator Baruch, I'm sure he'll want to be on it too,
Okay.
if you don't mind.
No, I'll check.
So we'll just plan on getting it ready and having it taken up and then let Senator Baruch know that, because Eric's not here Friday, we can do it on next Tuesday or whatever.
Sounds good.
So I'll draft it up, send it to Ben so you guys can look at it.
Yeah.
And then, I can let John know that it's coming, so it'll be.
I don't know that I have to look at it. And respect is pretty simple.
Yes, it is.
I don't think any of the amendments that ever get a simple draft.
Right. Well, I'll let John know at least that it's coming at least.
Yep.
So it would be on notice tomorrow, presumably?
Yeah.
Right.
Awesome.
Right.
All right,
Great, thanks.
thank you. Thank you for identifying the problem.
Yes.
Okay, our next bill is H 645, which is a much. Thank Ben and Senator Bahowski for working on this bill and trying to make sense out of the mess. Well, I shouldn't say that.
It's definitely complex, which I think is a
Thank
little
you.
bit of a
So to help with that,
speak to the underlying framework of things. Thank you.
Senator.
Oh, thank you.
Maybe just Senator Sheen, copy for you, Senator.
Thank you.
So this is just sort of a handy cheat sheet, if you will, of what the bill does and does not do. What it does is on the first page, what it does not do is on the second page. I will send this to you if you get posted. I can send this to Ben if you want to
Yeah.
post it as well.
Yeah.
Okay. I'll email it.
Yeah, no worries.
I have a few extra copies. Yeah, if you wanna, I only have two others, so. Big guns today. You guys can share.
Yeah, sure.
Tim, you brought the full boat today.
I think John brings me, not the
Oh,
other.
well, that's what I was saying, yeah, you were allowed to enter. Okay.
Okay, our first witness is Tim Waters Dumont. And John Campbell is taking his place.
If it's okay, Mr.
It's okay to
Chair.
take his place,
I could take his place.
you're in charge.
And I'm, again, John Campbell, Executive Director of State Attorney's and Sheriff's Record. Mr. Chair and committee members, I'm just here, just very briefly to just kind of offer an overview of an issue that I see with it, and then Tim will go into the specifics. Well, I understand that there is a desire to get more data together and to create a more stable funding stream for the CHACs, which is great. I think that that's laudable. I think the fact that this bill, and as you mentioned, it is a complex bill, and it is going to create more work for us, which we don't have the personnel to do. It's simple, and again, Mr. Chair, with all due respect, and I know with the appropriations, it's tough. I know that, I listened to testimony from yesterday, and with the positions that were suggested, there's just so much we could do, and we're overflowing. We've got 36 different committees that we have to go on after session. We're either study committees, legislative committees, or other types of committees. The offices themselves are just, I have, as I mentioned to you yesterday, we have three deputies now that are contemplating moving to private sector because they can't take the stress of the overwork and the burden of the cases. This is happening all through the state. We've shown you the numbers, and there's just so much that can be done. And every time a bill comes up, if it requires us to do something more, it's not just with the deputies, but it's also for the administrators and it's for the victims advocates. So I just, you know, I keep on saying it over and over again. I just don't know how, we are going to be able to accomplish all these additional duties, with, you know, with the positions and the resources we have currently.
Okay. Senator Bowles.
Yeah, can you help me understand how it's gonna create more work? There is no requirement that state's attorneys develop a policy, and I would think that if more things are being diverted pre-charge, it would actually lower caseloads and create less work.
What is not been described in here is the work that we have to do with all of the partners that we work with. All the law enforcement agencies would have to be retrained on any policies, and the policies are expected to be have here. Representative Dolan said that made a statement in House Appropriations that this was just the start of expansion of this program, and so therefore, you know, who knows what's going to happen next year, but again, we're here for this one. Tim will go over the specifics of the areas where the additional manpower, additional resource needs that will happen. But this, anytime that a bill is created, and again, I understand how it happens, because when legislatures they have ideas or recommendations to pass laws, and that's great, and they to change things, to help things, but sometimes they don't understand what actually happens in the field. And if you don't know the actual occurrences in the field, then you lack the knowledge to see where the resources are necessary.
Yeah, I guess I'm confused, given that there is no requirement that state's attorneys change anything, that if the state's attorney's office doesn't have the manpower or the capacity, they just won't do it.
I would respectfully disagree. I think that is going to be expected for us to be doing, carrying out what is set forth here. And this is in the House version.
Yeah, I'm confused, because in the House version, it says that if the state's attorney's office doesn't have a policy, then they pre-charge money won't go to those community justice centers. It doesn't say they have to develop a policy. It doesn't say, so I'm just really confused.
I think that the goal here is obviously to get the community justice centers up and make sure that they're functioning all throughout the state. They want consistency. As you might know, is that the CJCs are not all equal throughout the state. You know, Chittenden County is fortunate; they have a lot of resources, and the other CJCs around the state are not so fortunate. They are manned mostly by volunteers, which is great. We do work with them all the time. It's not that we don't work with them now. It's just that these policies, I think, are going to, not I think, I believe they're going to be definitely causing more resource drain for our offices. So we're going to be working with the Attorney General's office, and the Attorney General's office, while they handle the diversion programs and these pre-charge programs, we're the ones that deal with the crimes that are associated with them. And again, I'll defer to Tim to go walk through the specifics to give you a little more analysis on exactly where the resource drain would be.
Let me ask one question. Is your preference to change the bill, or is it to kill the bill?
I would never come in here and say we kill a bill. This is obviously the province of the legislature. I think, just as I've always done even during the legislature, my time in the legislature, is that if there is a bill there, you try to make it better and try to make it work for all parties concerned.
So if we took out the section that requires adopting, I mean, it says you're not required to adopt policies, but obviously you get penalized if you don't.
Exactly.
So we took out those sections. Would that be more back to the real, the way it is today? You know, I'll describe what Erica Martha, Bennington State Attorney, described to me. Rather than checking off boxes, I'd rather talk to Letha and talk to her about whether this person should be pre-charged, post-charged, or whatever in the phone conversation. And if I'm checking off boxes, I don't have time to call.
I didn't want to use the term red tape, but I mean, this is gonna create more bureaucracy, and I think that's what happens when you have, see, one of the things that people are forgetting also, and this is going off into a little bit of a tangent, is things have changed. The prosecution of cases is not the same as it was 5 years ago. Because every case you have now, you have body cam footage. This is just for one example, which the prosecutors have to go through every part of that, sit and watch all that body cam footage just to make sure that there's no exculpatory or inculpatory material there. That takes time to do that. I mean, our prosecutors are not just sitting there, with their feet up on their desks. Everyone of them working extremely hard. And the office is the same thing with the admins and our victims advocates. It's the numbers are there to show that. And anytime that you create something, even with the expectations that yes, you're going to do this, and if we're not going to do it, if the state's attorneys are not going to do it, then who will?
Well, I just want to send a house. What is most galling to me in dealing with these three agencies on the appropriations committee level. The Attorney General's office has certain versions. Department of Corrections has community justice centers, which are supposed to be restorative justice. And then the Department of Children and Families has the BARGE programs. Trying to figure out, and many of the programs deliver on all three grants, some one grant, some two grants, trying to figure out the budgets that are allocated to these programs is like checkers, or maybe more like chess or dominoes. I don't know. You pull one and the dominoes fall. It's really bizarre. And for example, the corrections budget funded according to the commissioner, funded 2.2 million in base last year for community justice centers. It then funded out of justice reinvestment approximately 900,000 for a total of 3.1, I believe. Well, he says that it's not a cut to go back to the 2.2 million base. The justice centers feel like they're being cut because they spend it as base. They weren't informed they say they weren't informed it was one time, but it was justice reinvestment money. So what do? I'm stuck trying to figure that out. Your budget, as complex as it is relatively easy because you put together a budget and we can see what is going here, there, and everywhere. Now, then we got the BARGE program, which they don't know what the impact is of raise the age, so they just came up with a 1.1 million. I have no idea. They have no idea because it didn't cost 1.1 million to raise the age to 18. So, it's just always confusing. That was out of DCF BARGE program. And then you have the Attorney General's program, which is a little bit simpler to understand because they just asked for 290,000, I think. I won't give the exact figure. This was all going through my head when I'm trying to balance state's attorneys, judiciary, defender general needs, and the rest of the community justice system when I'm marking that up on Saturday. And I'm thinking to myself, what a mess this is caused by having all of these different agencies of state government funding the same programs in some cases. Other cases, some of the programs are just community justice centers, like I think Williston. I'm not sure. So Senator Bowski, you had a question?
Yeah, well, both. I think I agree with you that the funding mechanisms are messy, and I would like to see us get to a more streamlined space. And in my view, this starts to move us in that direction. My question for John is, would it be better if we just set a pre-charge policy and handed it down to state's attorneys?
That would be a violation of separation of powers pretty clearly. And Tim Leaders-Dumont from the Department of State's Attorneys and Sheriffs. So right now, we're doing post-charge diversion in every single county. like 20 to 25%, Willow would have the proper number of all misdemeanors, again, referred post-charge diversion. We are heavily utilizing restorative justice pathways.
Okay, can you tell me the difference between
Yes.
a diversion program and a restorative justice program, or does somebody in both?
So restorative justice would apply to both pre-charge and post-charge. It's the overarching concept. Pre-charge, from our perspective, but definitely contrary to the definition of pre-charge in this bill on page 1, is any referral that takes place prior to the filing of a criminal charge or a petition under Title 33, which is juvenile delinquencies. This bill requires, while it doesn't require an affidavit, it requires a finding of probable cause. While that may work in some circumstances, in the circumstance you described with State's Attorney Marthage, that isn't the goal of the conversation. The goal of the conversation is, can we, maybe there's probable cause, maybe there isn't, can we divert this person? Can we eliminate potentially paperwork that we then have to delete or expunge or seal in the future? Can we deflect this person entirely? We are already dealing with such a crisis in the post-charge environment. We are in 11 counties: Windham, Bennington, Windsor, Orange, Caledonia, Essex, Orleans, Franklin, Addison, Chittenden, and Washington are heavily utilizing pre-charge. Some of the issues that we've come into contact with are, when I was utilizing pre-charge in Washington, I would get a call from a police officer here in Montpelier, and I would say, "Thank you for calling me. Would you want to go to trial in this case? Would you want to be the star witness in this graffiti case?" "No, I don't want to." "Okay, great. Let's refer this to the Community Justice Center here in Montpelier." No paperwork were filed. And I said, check in on the case in 30 to 45 days. See if they're engaging with the CJC program. Informal, fluid, improvisational, something I didn't have to bring into court. Now, I don't know what's happening on the data side on the CJC side. I think a lot of the aims of consistency of funding and consistency of data collection can happen without, from our perspective, 11 counties would need to train all the law enforcement in those 11 counties, have new records, policies regarding how to deal with cases, talk to victims about a case where a case is sent to the CJC. There's a huge amount of work that happens when you change things in statute in the pre-charge environment, which is in my opinion, this would be there's been a lot of progress on this bill from the time it was introduced, but it still has, from my count, hundreds of uses of the word shall, which means that we must do things if we want to utilize things. And we don't want to, getting to your point, we think that we don't want to punish the CJCs for not adopting a policy. And from our perspective, it would be the Attorney General's office that would be interpreting whether or not we've complied with publication. And I'm happy to walk through the bill. I've spent hours and hours of testimony in the House, both prior to crossover and also prior to the session, engaging on this topic. And I'm happy to walk through the bill to point out a series of technical comments as well, if that's helpful.
Senator Bowes.
So 11 counties are doing pre-charge. Are you telling me none of those counties currently have a policy in place?
That's not what I said.
Well, you said 11 counties would have to change everything that they're doing,
That's correct.
but all this says is they have to have a policy. So if they already have a policy, they wouldn't have to change anything that
The
they're doing.
policy may not comply with what this bill contemplates. So for example, in some counties, there's what I would call multiple versions of pre-charge practices, depending on the law enforcement agency and the state's attorney's conversations. And what this bill would do is, let's say in County X, the policy was basically, we trust the X police department to send any case to the CJC. That's effectively the agreement. It happened by a phone call. In another part of that county, it's every single case needs to get sent to me, just the name of the person, so we can do a quick check in the office to see if they have anything pending. That's how pre-charge practice is happening. Some places they have a written policy, like in Washington County, we had one, but it would need to be updated, retrained, and because of the records deletion provisions in this bill, we would also need to potentially segregate records and retrain staff. And I'm actually not sure how to comply with it as of yet, as the records officer for all 14 offices. I'm confused about how I would comply with that in terms of records retention and what would need to be deleted, sealed, etc. But if you look on page 7, each state's attorney, and every time we talk about the juvenile section, there's a mirroring adult section. So just the comments apply to both. But if you look on page 7, and this goes into the comment about the CJC would only, of the as-passed version, the CJC would only receive funding if the state's attorney publishes a policy. In that policy, the state's attorney shall include the following: a list of offenses that presumptively qualify for a pre-charge. I just want to pause right there for a second. We're talking about an environment where we have not charged anybody. So to define a series of offenses, we're talking about conduct that resulted in law enforcement contact. We're not talking about offenses. We're talking about conduct that resulted in law enforcement contact.
Interesting. I have a note here that says this whole section's wrong.
Well, I think that was a piece that we were gonna strike, was the list of offenses, and we were going to presumptively assume all offenses could be.
Yeah, unfortunately, we have just the House version to go.
Right, well, we don't have an
Yeah,
amendment to that, I just wanted to give
Yeah.
you the information that
Right, that-
piece right
yeah.
there is
Has
gonna
been
be struck.
flagged, okay. And I think that's an important piece because we don't, as one former state's attorney who's now a judge said to me, I'm not going to predetermine and pre-assume my finding of probable cause without actually filing it and having a judge review it. That's how prosecutors review our finding of probable cause. And that relates back to the definition of pre-charge on page 1, which is that you must find probable cause. Right now, we have lots of pre-probable cause referrals, whether they're called community or pre-charge referrals. They're happening prior to the filing of a charge. Yeah.
But to be in diversion, one has to admit that they did something wrong. May not be exactly what the charge says, but they have to admit that, and then they try to right that wrong by whatever the diversion board comes up with, or the community justice center, or DCF. So, yeah, I would agree that that's probably unnecessary, because I mean, if they refuse to admit that what they did was wrong, they're not gonna get diverted. I mean, they won't be accepted by the diversion. I'm using the wrong words. They won't be accepted by the diversion program, then they have to go back to court.
Well, but they wouldn't go back to court because it's pre-charge, unlike post-charge diversion.
Wait a minute. So if I did something wrong and you offered me diversion,
Pre-charge diversion. Yeah.
pre-charge diversion, and I go over to the diversion board and say, screw you, I don't think I did anything wrong, they're gonna just let me go?
This will be an area to be sorted out, right?
Well, I don't think that's right.
Right now, it's not clear. It would depend on the policy of the state's attorney. And right now, for example, I used to send things pre-charge and say, within 90 days, please let me know if the person's been successful. I'm just going to tell you on the record that occasionally I didn't get an email back within 90 days. And that's because people are trying to do their best every single day. But so I would have to dog a case because I believed in trying to sort it out before filing.
Well, I want people held accountable if they're not gonna participate in the pre-charge program.
It would depend on the policy.
So I don't
and the
think that's a
procedures.
horrible policy, that the diversion director report, or whomever, community justice, report to the state's attorney that the person failed to successfully complete the program.
Or sort of better, right? Because law enforcement is sometimes the initial deflection point, we would want law enforcement to be the one receiving it so they can kind of continue the investigation to see if there is a case, probable cause.
Whatever you want for language there, I do think that's necessary. It's in there. It's in there.
It is, it's on.
Yeah, so the way it does that, the policies would have, so again, it's up to the complete discretion of the attorneys, of the state's attorneys to create the policies within those the confines that are outlined there. One of the aspects that need to be contemplated is a return of the case if they don't successfully complete, or the provider does not think that the person is suitable for diversion, a process to return the case to either the prosecutor or law enforcement for them to do as they feel.
And that goes to one of the issues. We don't have a training coordinator in our department. It's each state's attorney would have to sit down with each law enforcement agency, each chief, and say, here's how we're gonna do this. And right now in those 11 counties, we're not hearing complaints about this not working well. And so what we're saying is, on the CJC side, on the data collection side, on the funding side, when someone walks in the door, let's say I've walked in the door because I've been referred by law enforcement to go to the CJC. What brought you in here today? I was referred by law enforcement. That's a data point that can be collected incredibly easily, hopefully, and it doesn't require any new work on the Department of State's attorneys and sheriffs. We're still going to send the referrals. Whether or not this bill becomes law or not, we're going to use pre-charge. We're going to use community referrals. And the compliance with this is something that, I know it's gonna fall on, the individual offices who are also gonna turn to us. How are we gonna comply with this? Here's how we're currently doing our policy. And in Windham County, I sent along a comment from State's Attorney Schreiber to Senator Hashim, which you certainly can share. She said it can be shared freely, but, right now they're doing an incredible effort in Windham County, basically a restorative justice day in Windham County, where she sends people, the prosecutor sends people to a day where they engage with their panels all on one day, and the cases get deflected and never filed. That type of improvisational work, I can't tell you, it might still work under this, it might not. There's concerns from those using pre-charge right now that this bill is not going to necessarily make things easier in a system where right now we're deflecting, we're diverting, we're doing all sorts of stuff. And I was a pre-charge practitioner here in Washington County that can tell you that we had a policy that was really helpful to me and to law enforcement. In other counties, it was an email or a phone call or an understanding. And I think when the new work.
And that policy did not necessarily work for every one of the counties. They're not, each one of them are separate, and they're dealing with, let's say, law enforcement in certain counties are stronger, probably more experienced than others. And as I said before, even the CJCs are different.
Summary, you're opposed to the policy requirement. You're opposed to the notion of a probable cause. And you agree with us that section,
The list of offenses.
the list of offenses is wrong, that any offense should be up to the state's attorney.
Any conduct, yeah.
Can I say, Mr. Chair, I'm sorry, I know Mr. President, but, Mr. Chair
I
is.
like being president.
It's not really opposing as much as it is saying that it's either not necessary or the fact that it is inconsistent with what we do on a regular basis. And it's not an opposition. I think we'd all want the same thing. That is to prevent people from getting into the system.
And and deletion of records is another area that overlaps with H655. When we're deleting records, we can't then determine in the future if that person might be successful with restorative justice. Likewise, we might be unintentionally violating their Brady and Giglio rights when they are sentenced for a future case. Have you ever engaged in restorative justice practices? Have you ever been successful? Under this bill, those would be deleted, and we could not use that to mitigate their sentence in the future. Likewise, the index by the Attorney General's office where the person's names would be kept. My opinion is that would potentially be a per se Brady Giglio violation list, because the case would be deleted, state's attorney wouldn't have access to it anymore, and the AG's office would be maintaining an index of person's names. I would refer every single defense attorney to the AG's office to check to see whether or not they've had successful pre-charge.
Okay, so Suzanne and then Senator Bowles.
So just for full context, the special index is the same as the special index that is created under the diversion program now, that's housed within the Attorney General's office. So it's just the point in time in which these cases are being handled. Additionally, there was a provision written in that private information or, a Valcor database or other similar private database information held by a law enforcement or state's attorney's office.
Sorry, it doesn't say state's attorneys, it only says law enforcement. So we wouldn't be exempt from that. It says law enforcement agencies. We're a criminal justice agency.
I have no idea what you're talking
Yeah,
about.
it would need to say
I'm just
criminal.
saying they don't have to, they're not required to delete it.
Oh, okay.
If it's a
That's not how I interpret it.
similar, private database.
Okay, well, I trust my alleged counsel.
We are a criminal justice agency under Title 20. We are not a law enforcement agency. And so we would need it to say criminal justice agency so that we wouldn't, right now, law enforcement agencies under this bill would not have to delete, but my review of the bill is that state's attorneys might have to. And I think that was unintentional. In the House, they were trying to have it in there, but criminal justice agency is what
The as passed by, this is on page 15, lines 10 through 15. Within 30 days after the 2-year anniversary notifying the law enforcement agency and the state's attorney's office of the participant's successful completion, the Attorney General shall provide certified notice that all public records held by the law enforcement agency and the state's attorney's offices shall be deleted. Public records do not include the Valcor database or others not similar non-public law enforcement databases. So I think the intent was to capture,
Right.
it, but if that needs to be clarified, I think that that's something
Well, I
that
have
can
a
be.
note here to delete the word certified, by the way.
Yeah, I know that that was a recommendation.
Right. So yeah, criminal justice agency under Title 20 would get you to that point where we wouldn't have to delete things. And that's one of my walkthroughs of the bill.
And if I may, Mr. Chair,
Yeah.
on line 15, to add non-public law enforcement or criminal justice database or criminal justice agency database.
Yes, that would be great.
Does that loop in more than just state's attorneys? What else does criminal justice database include?
That's something I can't speak
It would
to.
include all law enforcement as well. It's sort of an umbrella term under Title 2056A that we use in the sealing context in terms of the definition of a criminal justice agency.
Which was not actually my question.
And then the other piece when we're in that realm is unlike expungement of records where we can object, if someone is successful, but then they pick up a new interaction that we consider to potentially be important in the context, we have no ability to object to deletion in this bill, which would be different for two reasons. One, in the expungement context, we're dealing with court records, so we would be objecting to a court. Here, I'm not sure who we would be objecting to, but this is because it's all pre-charge. We can't say in the matter of 20 CR 335, we object because the individual has picked up 17 new alleged charges. Here, it's a little bit more nebulous. And so, and I hate using this type of terminology on the fly, but basically, in the interest of justice, it's possible that we may think that someone's deletion of their records shouldn't take place because of other conduct or community conduct in the community, which is what we do in the current post-charge environment.
If we're not talking post-charge, we're talking pre-charge.
So that's why it's even more concerning because we don't have the ability to object to the deletion of a record like we would in post-charge.
But they haven't been charged with a crime. Why should they have a criminal record?
But there's still a record of law enforcement contact. There might be a record of a case review in our office. There might be, let's just say, like a form, if this bill results in a series of forms about the person's conduct that have been summarized in some format. So we'd be deleting all of that. And when a victim then reaches out to us and says, hey, I know this case was sent to the CJC, or the defendant says, hey, I know this case was sent to the CJC, and they were successful, I want all the records, we'd say, well, there are no records. And that gets to some of the issues that we've run into with expungement as well. So some of the same issues with expungement we'd have here, we just have less recourse to object.
I mean, I have to believe if someone picked up 17 new charges while on diversion, they wouldn't be successfully exited from the program.
I've seen people that have been very successful on a number of occasions and then have a very bad year and then come back through and they're not being successful because, the fluidity of people's lives is sometimes they're successful, sometimes they're not.
I'm trying to, are we getting anywhere?
I mean, this is my first crack at the plate on this bill in the Senate. I had, 5 hours of testimony in the House. It's an enormous area of our society that we are trying to put our arms around. And so from our perspective, there's ways to accomplish the goals of better consistent funding for CJCs, more equitable access without worrying so much about utilization. 11 counties are currently utilizing pre-charge practices. Those, we're going to want to use great programs in our communities. We're going to want to deflect and divert upstream, where John has said on a number of occasions, upstream resources help us downstream. So I think there's a way to focus the bill without having mandates on state's attorneys that want to use pre-charge.
Senator Bowski.
There is no mandate, and I agree with John that upstream efforts will decrease your downstream workload. There's no requirement that state's attorneys adopt a policy. There's no requirement that it be the same policy. Lots of state's attorneys, I know my state's attorney has an excellent pre-charge policy that
Which would need to be drastically updated to comply with the bill.
Well, if we
I
take
don't
the
know that that's
policies
true,
out,
but I have reached out to her.
As have I.
if we take all the reference to policies out,
And for us, if we have a policy, I think we'd be happy to publish it. Like, if there's a policy, it should be published, right? But mandating from our perspective, we would see this as a mandate because we're using pre-charge right now. So it isn't something, and if we didn't publish a policy under this bill, the CJCs would lose funding, and we do not want
I'm
that.
suggesting we take the policies out.
I don't feel good about that.
Right.
I feel like people have a right to know what the policy is. I think formal policies decrease bias and let people know what the process is. I don't feel good about saying, sure, just do whatever you want. You don't have to talk about what the policy is and how you navigate that policy. I think that this is a move forward to making sure people understand the system. They understand who's eligible for pre-charge and how that process works in a more formalized way.
Senator Doshi.
So with whatever the individual policies are now, why can't we just require that they are published to get to that same point?
Yeah, that sort of angle, I think, would be more apt with resource concerns as well. If you have a policy, it should be published. That's something we can encourage our state's attorneys. Maybe not all of them will be in
I have
favor
no
of that.
problem with that at all.
But if there's a policy, we'd be happy to have it be published and publish it with the diversion office of the AG's office as well. I think one of the things that we want to make sure is if state's attorneys get elected, sometimes they leave office, making sure that state's attorneys can use these resources without having
And I
publication.
think the one thing probably makes it a little more difficult is because it is almost on a case-to-case basis. You know, you're dealing with individuals, but not everyone's alike. You know, it's not all vanilla here. And so to have a set policy, sometime I think would probably act as a deterrent in a way to try to fit everybody into the mold. So I think that's why, each one of the state's attorneys who don't have a policy, which I'm not sure how many do, probably know better, they would say they would have the flexibility in order to deal with cases on that.
Well, if they don't have policies, what do you do about the allegations of bias?
In what, against law enforcement or state's attorney?
Against state's attorney, they're biased against
Yeah, this is one of the,
group because they don't have any policy, and X person can't get the two people who do the same crime, one's black and the other's white, and the white person ends up in the diversion program, and the black person ends up charged and convicted, blah, blah, blah.
yeah,
How do you deal with that allegation of bias since you had two people, same criminal activity? You may have had the state attorney may have had good reason to do that, but that's what leads to those charges of bias, I think.
yeah, no, it's a really good point to
So I
to
think
dwell on.
you don't have to punish, but you can require at least posted policies.
Right, if there's a policy, it should be
If
posted.
there's a policy, it'd be posted, but I think you have to require a policy.
Yeah, I was gonna say, just saying post it if you have one leaves people free to not have one and not post
I
it.
don't think you need to be punished by your diversion program not getting money, because it's not their fault.
That's right.
So I think that's really wrong-headed, actually. But I do agree with Senator Bowski and Senator Baruch that you should have a policy and it should be transparent. It only protects the state's attorney, really, against those charges,
Yeah,
in my opinion.
the environment that we're talking about is, I think that I personally benefited from a policy. So I'm speaking from a Washington County thing. We had a policy, law enforcement generally understood it. So I'm only speaking from my own experience.
Here's if I may, what I think would be a good idea, and I apologize, and I'll take the hit for this, is that we should have had, know right now, like which officers do and don't, or what their policies are. So I'm happy to report back to the committee as to, what the policies are.
Are there any state attorneys that don't have a policy?
That's, there's, three counties that don't
That
have.
don't do pre-charge.
Right, there's 3 counties that aren't currently doing pre-charge.
So I would imagine what we're going to hear is that every office has a policy, but not all the policies are written, in writing. So, I will speak with the state's attorneys and, find out, and if there is objections on their part, for some reason, bring it
Yeah, I
back.
would appreciate that.
But I think all of us in this room are probably the same.
Yeah, I think, and usually when we require policy, it's the agency that gets punished if they don't have the policy, not the
Right. Not the CJs.
not the CJC in this case, or. whomever else might get.
Yeah, tying in the publication of a governmental policy to the funding of what can be non-governmental entities is something that
Yeah,
we don't think is good policy.
I don't either. I think that's the wrong route. If you're gonna punish somebody, punish the state's attorneys.
We get punished enough.
I have a
It's question.
question around the probable cause piece. Is this what we're talking about here? Would that create, because my state's attorney has now gotten back to me. And the piece around it, so on page 9, right at the top of the page, the juvenile post-charge diversion program for children or youth shall only accept individuals against with whom a petition has been filed and the court has found probable cause but are not adjudicated. Is that the piece that you're talking about when you say that having to find probable cause?
That's post-charge.
Okay, so where is the probable
So,
cause aspect that you're concerned about?
Page 1, the definition of pre-charge.
Yeah. Means to refer to an individual
Line 16.
Yeah, I see it has,
committed a crime.
I'm not sure, I just don't think that sometimes you get the inflation of a lot of these terms, and I think that's maybe.
Post-charge, you need probable cause.
no, that's
Yeah,
fine. I just was I was like sifting quickly through the bill, trying to find the word probable cause and trying to figure out where the issue was. So I appreciate you pointing me to where the issue is.
Yep.
Mhm.
I can speak to why
Okay.
it was done.
Go ahead. Or, sorry. I'm just trying to understand.
So there was concern raised in the House about what is pre-charge diversion. Is it those community referrals, about maybe like a school conflict that doesn't rise to the level of something that would be criminally charged? Does it involve something more? And as you heard from the restorative justice providers, earlier, they are very concerned about how this does affect those other referrals. So this was an attempt to narrow it. And also the state's attorneys raised concerns about basically, they may not put in the work necessary for, it's a cost benefit analysis that they may not put in the work for something that doesn't rise to the level that would be basically chargeable. And so there was an attempt to define something substantial enough where it was worth putting in the work, but also leave those other referrals untouched so that the work could continue on status quo for those other community referrals. So that was the needle that the House tried to thread with that definition.
Can I ask a clarifying question, because I'm not a lawyer? Does the state's attorney, based on this language, have to go through and prove in a courtroom probable cause for everything they refer to pre-charge? Because the way I read it, it says an officer or prosecutor has determined probable cause, so therefore the officer could say, here's why I think
So
it's probable
there's
cause.
sort of an individual, I think, assessment that happens by a law enforcement officer or a prosecutor prior to bringing a charge. It's to capture that, but really right now, probable cause is found at arraignment by a judge formally, which is why the post-charge diversion program is designed that way.
So if you have a truancy program in your CJC, and you're working with the local schools, state's attorney, and in the case in Bennington, the judge, to prevent truancy, you have a very hard crime to prove because it takes so many. But that program is very effective. It started at the Molly Stark School, which is located right where the 2 low-income housing projects are in Bennington. So a lot of the kids there were truant, and the then principal years ago worked with the state's attorney and the CJC to begin a truancy program. Now the judge has kind of adopted it. So it's more of a threat, but I don't know that there's probable cause that a crime's been committed because the kid is truant, for 7 days. In many cases, there's good reason that the kid was truant, but they need help from the parent to try to prevent future truancy.
So, and that's, I'm sorry.
So how does that fit in with the requirement for probable cause?
So it really would fall outside of the bill, and that's why if you look, there's the community referral sort of report later at the end of the bill to explore the expansion of that program. But right now, whatever programs they have for those truancy or those community referrals that really don't rise to that level can operate status quo. This bill doesn't affect that.
In
Or it's not
order,
intended to, based on the testimony in the House.
in order for a police officer, so say, I usually use myself, but say I'm using someone else, say Notter is arrested, and the officer wants to file charges, what is the language in statute that that officer has to meet? Is it probable cause to, or is it more likely than not? Like,
Well,
what
the officer would draft an affidavit of probable cause that would be sent to the state's attorney with sort of the recitation of what occurred in the incident. And then ultimately the prosecutors have that charging decision about whether or not to do it. But they oftentimes, and I think, you know, attorney leaders do want to testify to this, like they talk to each other about, well, you know, does the evidence exist? They make that cost benefit analysis sort of long term to see, you know, so there might be facts, but basically are those facts going to exist when the trial is ongoing? You know, are you willing to testify and be the star witness as he said today?
So in this language, if the officer files the affidavit of probable cause and the state's attorney and the officer talk and decide it should go to pre-charge, does that meet this requirement?
I mean, theoretically, yes.
Okay.
I think we can take the probable cause out.
So, yeah, I think what's happening here is there's a desire, we know that there's behavior that occurs that is not, let's call it not healthy behavior or whatever, but it may not rise to criminal behavior. And I think that they're trying to, you know, we're kind of getting brought into that arena where it's not criminal behavior, and that's when we really can't be there, because we have ethical obligations also. We can't bring charges, and because no charges have been brought. So if it's a case where somebody, there's interaction, there's police officer, law enforcement interaction with somebody, let's say it is something at school. If it's not a crime, if they haven't charged it, then, we can be there as far as to offer advice whether or not there is criminal behavior, or we think there may be, or this is what has to be proven to bring it forward.
But the way I read it, this is explicitly trying to make sure you're not brought into the community referral cases by saying, actually, there has to be
I'm
the
not
belief that a crime is happening.
I'm just saying that that's where I think when the House, when you guys were talking about that, Ben was when he was drafting this thing, you realize that. So, and
to try and separate that
right,
out.
exactly.
So that's why I feel like this language is important.
I'm agreeing.
Oh, okay, you're agreeing with
Well,
me.
somewhat. There is a.
The way I would define pre-charge, having used it on a number of occasions, is law enforcement contact that results in a referral prior to the filing of the charge or the filing of the petition for juvenile delinquency. That's what pre-charge is. It's not necessarily, there could be probable cause, but it's a referral prior to charge or filing of the petition.
Okay. Are there any other questions for the state's attorneys?
So I do have one quick question. So if criminal charges have not been filed, there's been a referral, at some point the individual is given the choice, right? Whether they want to accept this path or take the other path. Okay, so we're contemplating getting rid of probable cause.
Yeah.
No time?
I don't like it, but go ahead.
So I'm just wondering are we setting up a situation where we have pressure on individuals who we're saying may not have probable cause to have committed a crime, yes, they're diverted from the big system, but now they're in the restorative justice system on just the word of the police officer that they should be there. Am I misunderstanding that?
Well, just to answer, so the process that's contemplated in this bill is that, and I think it's kind of helpful to give the example sort of about how diversion works currently. Typically you appear at the courthouse. Sometimes you'd actually have to physically appear before the judge, and the judge would say, this case has been referred to diversion. In Burlington, I would go to another room right outside with the defendant, meet with the diversion coordinator, go through the diversion contract, and kind of explain what this process codifies into law is that during the pre-charge diversion, the person has the access to a public defender, free of charge if they so request. So it does provide a little bit of protection
Okay.
there to explain the consequences of choosing one path or the other.
Yeah, okay.
The inherent issue with pre-charge is it is pre-charge by definition, so we are not filing. So there is no probable cause that we have signed our name under the state of Vermont to. So that's kind of the tension, is it's contact with law enforcement that was problematic enough so that it actually may have, gained their attention or resulted, I was called to a state's attorney, but it's more of this informal, yes, we think you should probably send it to the CJC. If they're not successful, continue your investigation, and then we'll figure out whether or not we should file a charge.
My opinion is you'll have fewer people pre-charge if you put this requirement.
That's correct.
Because your officer has to do all the investigative work to prove probable cause, so they might just as well go to court.
I think it may result, if you find probable cause, it may just result in a post-charge diversion referral.
Right.
Even if those offices are eventually unified, might be going to the same office, but that's not the current landscape. That I know.
I think trying to protect that is gonna, in the long run, hurt the current process.
And I do have one more quick question if I could. So back to the 3 state's attorneys who don't have a policy. Just wondering from you guys, is it your intent to protect their right to not have a policy? Or do you support this bill making sure that everyone has and publishes a policy?
So de-identifying which 3 for the purposes of their slight ambiguity at the moment. One of them I think would absolutely use pre-charge, but they don't want to hurt the post-charge office in that county by sending more things to the pre-charge office, if that makes sense. I think all 3 of them, if there were more equitable access in the communities, would likely use pre-charge.
Hurt them in what way?
So in some counties, there's a post-charge office that works with Willa's office, and then a separate CJC that gets other grants, as you were describing, Mr. Chair. And in those types of counties, a finding, let's say the current construction of the bill, probable cause occurs, and they want to send a pre-charge, it would go to that CJC office and not that post-charge diversion office.
Right, but so am I understanding you right, that it hurts them in the sense that they lose grant money because they're processing fewer?
I couldn't say, I just know that that's a concern about.
Understood, but
when it's not a unified office.
It's a concern maybe that's out of touch with the overall purpose, which is if we have fewer people going further in the justice system, that's to the good. But if we're listening to complaints about people who want more money further on down the line, that's not good, because it's essentially saying more people moving through the system is good for us.
Yeah, it's business. Right. Well, and I think right now, and I occasionally would have a defendant from another county, and I would say, why don't you go see the CJC in the county where you live? So the idea that we're also cordoned off into 14 separate spaces is another, Vermont's so small. And people who, I would say in those 3 counties, I think there's a likelihood of greater utilization and adoption if there's an actual CJC that's accepting, or a diversion office that's accepting pre-charge there, if that makes sense. It's not really about our lack of policy, it's about the lack of ability to refer.
Well, I would also say it's lack of policy is not a good thing. But thank you for that.
Yeah, and in case by case analysis, I think there are cases that have been declined, or hey, continue the investigation, and they do their own referral to a CJC.
Ben, what did you want there?
So
You said I was wrong.
No, I did not say you wrong. What I was saying is that I wanted to just elaborate further about why this probable cause language and additional provision was added in the House. Which was, again, one of the concerns that I kind of paraphrased earlier, was that the state's attorneys wanted to make sure that it was worthwhile to go through this process. But there was disagreement amongst the state's attorneys about, well, what goes into this process? That's why if you look under the required policy portion and on page 7, at the bottom of the page, there's this provision about appropriate documentation that can include name, date of the incident, a factual statement or affidavit of probable cause, because some state's attorneys discuss that they like just having a phone call with law enforcement agency some people expressed that, no, they want that affidavit, they want to see it. So it was worked in to provide that flexibility, but also to capture that, well, there's sort of this baseline. We don't want to bring in these other types of referrals based off of the concerns that the state's attorneys has expressed. So it was making sure that you set a floor that was essentially worthwhile for them to do, and then adding provisions within the policy itself to give state's attorneys the flexibility to operate these referrals in the way that they see fit. So it was balancing a lot of consideration to create some uniformity, but giving and having the state's attorneys retain their discretion as much as possible in how the process operates, and ultimately retain final discretion over whether to charge or not.
Thank you. But I thought that's the section we're taking out.
Well, I don't know if we're taking up a whole section or not. I just know that there's some discussion about it.
I feel concerned about sort of removing, and maybe probable cause isn't the right language, maybe there's different language, but I share Senator Burr's concern that people who shouldn't be pre-charge anything should just be a community referral without any type of guardrails could get sucked into the system, sure, at a lower point, but still sucked into the system when they could have just been a community referral.
Right.
So like, I do feel like the guardrails are important, and again, maybe this isn't quite the right language, but just allowing free reign of like, whoever you want to be pre-charge.
Judge Zoney has been chomping at the bit, and he was scheduled about a half an hour ago. May have some words of wisdom, and then we'll take a break.
All right.
Well, I apologize. I actually have been called into the healthcare committee in the House at 10:15. So I just wanted to let you know that
Well,
I
we'd
can
love
come
to
back
do
if that
that.
helps, or I can go now if that helps.
Well, if you have time for us, we'd appreciate it right now.
Yeah. So Tom Zone, Chief Superior Judge, as you've been discussing this morning, this is a policy. The bill, the only comments I would make about the structure of the policy are that there are provisions that provide pre-charge attorney consultations with the public. I just would want to make it clear that that is not something that would go through the courts. We would not have a case, and we would not be involved in that. That I understand Mr. Valerio, the Defender General, will take care of that aspect with the CJCs. And there is the provision of the bill in section 4 on page 54 that talks about a post-adjudication reparative program working group, and that includes the role of the Chief Superior Judge. And I would simply note that to the extent as a policy, that's a group that the legislature determines is appropriate to assist in going forward, that I would be willing to take whatever actions the legislature believes are appropriate, including those as set forth in there.
Okay, thank you. Any other questions for the judge? Judge, you heard quite a discussion about the requirement for a probable cause. And is that any concern to you that either it should be in or shouldn't be in, or agnostic?
Agnostic, but I would note that someone shouldn't be sent to someone should not be sent to diversion for a criminal charge unless there was a basis for that, right? And so as I read the probable cause determination, all that's saying is there has to be a reason, not just that it has to be a reason meeting the certain level that would otherwise go to court. And so I think that, again, that there needs to be a reason why someone's going, and putting that standard in. It's not as though it requires a formal filing with the court for the judge to find it. I read that to simply say that the legislature wants to make sure that before someone goes, there is a determination of probable cause and there's a reason. And officers make that determination for warrantless arrests determination. The state's attorneys make those determinations. So it's not a concept that is foreign to them.
Thank you. Senator Sheen has a comment.
Yeah, I mean, I think more of a comment. I was going back and forth regarding probable cause, and I think that, I mean, if we're going to end up requiring someone to participate in pre-charge diversion, I mean, there does have to be a basis for it. And so, yeah, I mean, it's it's actually pretty simple. I mean, there has to be, if the state's going to be ordering someone to participate in something and do something with their time, then there has to be a basis for it, and that basis would exist, I imagine, in probable cause. So I'm not sure what, at this point, the real issue is with leaving it in there. Or at least I haven't been fully compelled that it needs to be removed. I mean, maybe there's something that I missed and I'm not.
Yeah, just to build on that, I was responding to the idea that if we got rid of probable cause, then you could have a police officer just say to someone, I think you did that, you're going to diversion. It becomes a one-person operation to send somebody into the system, even if it's only in the pre-charge part of the system. So I guess probable cause is necessary in my opinion, or something.
And just one more follow. If somebody doesn't complete pre-charge diversion, is there a consequence to that?
So one of the requirements of the policy is to outline exactly what happens in that scenario. So that would be up to working it out with the CJC, the state's attorneys, law enforcement. It could include filing a charge. That's something that is within their discretion to do, or that could be the end of it. I mean, it's a broad, it doesn't say.
Thank you.
Yeah, thank you, Judge Zone. I appreciate your sort of reminder that this is something that happens every day right now, and all we're saying is that if this happens and someone decides pre-charge, the other option would be they would decide court. Like, this is not a new concept, so I was already, unsurprisingly, fighting to keep that, but with that sort of recognition that this already happens, I feel more so, and frankly, the more I hear about like what is being asked for in this policy, the more I think it's actually really important that if pre-charge work is happening, that these policies are in place and published.
And I agree, and the discussion points out to me, the words flexibility and discretion keep coming up.
Yes.
But there's flexibility at every single stage, including not having a policy at all, having, as was talked about, unwritten policies that supposedly everybody knows, but if it's unwritten, my guess is that people have different notions about what the policy is. So I think what we're doing is looking at the kinds of things that produce geographic injustice and produce bias on down the road, because so much of it is left up to people who are overworked. They're operating very quickly, they're trying to move fast, and they're not aware of the fact that they're adopting uneven standards with not only in their community, but with the other counties.
But I think it protects the state's attorneys too, to be able to go to and say, this is the policy,
Right.
This is why we did it this way.
I don't have a particular problem with the more I've thought about it, the establishment of the requirement to have policies. The problem is penalizing the CSJ
Right.
where you don't have the policy. I don't think that's the right group to penalize, because they didn't do it, they didn't have anything to do with it.
We could have a pre-charge program for the state's attorneys. If they don't publish the policy, they go into a pre-charge.
Judge, anything else to add? I realize the healthcare committee,
Is what it is.
in the House is probably mind-boggling, and I don't want to take you away from trying to think about how to deal with that group.
That was a last minute addition to today's schedule. In fact, they contacted me and said, what time were you done? While I was in this committee. So my pleasure to make sure we finish this up.
To enjoy with that group.
All right. Thank you. Have a good day.
Good to see you, and we'll see you soon.
All right. We'll be back. Thank you.
Thank you. So we're going to take a 15-minute break till 20 of, and